Hello, buddies. Very good evening. Guys, we study company law, we study SEBI, we study various meeting provisions in company law, and we study so many laws. But only when certain practical things come into the fore, we understand the importance of studying everything together, right? So, because of our good luck, I bring to you today, linking between Companies Act, SEBI, and other provisions to help you understand that what exactly goes on in the practical world. You might have heard about, Dish TV recently, just 2-3 days ago. So I thought I'll make a quick video on the history of everything. It's just a very short video which will make you understand everything. As you know, as per SEBI LODR regulations, you need to file, every listed company has to file certain documents, and of course when the AGM is held, you should immediately send the results, etc. within 2 working days. You know that, you would have heard. And also SEBI, if any of the companies don't do that, SEBI have tremendous powers. In my class, I've always told you, SEBI has powers to issue directions as they deem fit. So how is the practical applicability of that? And also under section 102, you would have seen, there are 4 things that happen at the AGM, adoption of accounts, that is consideration of accounts leading to adoption, appointment of auditor, appointment of director, that is rotation, and lastly, declaration of dividend. So guys, I bring to you the Dish TV versus Yes Bank case very quickly to help you understand all these provisions in a practical scenario. That is where a law student will definitely understand how things are done practically if you keep reading stuff. Let's do. So Yes Bank is the largest shareholder of the company, owning 24.78% of Dish TV shares, okay, 24.78%. Then you have IndusInd Bank around 3 to 4%. Now, how did Yes Bank actually manage to acquire 24.78%? That is what you need to know. You would have just heard the news about Dish TV, but you need to delve deep into the history to understand the entire thing. The bank had acquired the shares after certain SL Group entities. The entire group company is called SL Group, managed by Mr. Subhash Chandra, defaulted on a loan of 5,270 crore. Crazy. As security for these said loans, generally I gave a loan of 5,270 crore, Yes Bank. There was a pledge, pledge again you would have studied in CA Foundation and CA Enter. How important these concepts are, guys, today we'll come to know. So a pledge of almost around 47, 19, 13, 990 shares of the company, amounting to around 25.63% of the total outstanding of the company to Yes Bank. There was a pledge. It was created in favor of YBL Yes Bank Limited by security trustees. Of course, when you make a pledge, it is just it's a bailment. It is just handing over the possession, not the ownership. They were security trustees who were handling the possession. And who were they? They are called Catalyst Trusteeship Services Limited and IDBI Trusteeship Services Limited. They are security trustees on behalf of whom? Yes Bank Limited. The borrower was whom? Of course, SL Group entities, of course, which included Dish TV. Now, my dear friends, what happened? Of course, there was a default of 5,270 crore in the payment of borrowers. And then the security trustees, these 2 people, that is the Catalyst Trusteeship Services Limited and IDBI Trusteeship Services Limited, what do? They invoke the pledge. Once you invoke the pledge, what can happen, guys? You can sell off the shares and of course you can recover the money. In this, what happened, due to the agreement, the steps were taken up by the security trustees, and then those shares now, which are pledged against the loan of 5,270 crore, it was supposed to be transferred in their own name, that is Catalyst Trusteeship Services Limited and IDBI Trusteeship Services Limited, or as per the agreement, it was supposed to go in the name of YBL, that is Yes Bank Limited. Accordingly, since it was there in the contract, it was now transferred to whom? Yes Bank Limited. So Yes Bank Limited became owners of that whatever percentage, 24.78% of shares of Dish TV. Now Dish TV went to High Court because they felt that the ownership of that share should not go to YBL. They should sell the share somewhere and there should be a proper agreement and they should follow the contract. So there was a contractual problem. So every contractual problem you can go to the courts. So it went to the court and it eventually went to the High Court. In the High Court, they brought about a stay order. So Dish TV went to the High Court to ask for a stay order against whom? Restricting Yes Bank Limited from voting at the AGM. When was it supposed to be held? December 30th, 2021. Guys, Again, AGM provision section 96 will come into the fore. When should an AGM be held? Within 6 months from the end of the financial year. So it was supposed to be held in August 2021 and it got postponed. Again, it was supposed to be held in September, November or something, got postponed. Then it went to December. Again, there is a violation of Companies Act because you cannot keep on extending like this again and again. Extension will only be granted against very serious issues, like for example COVID. In 2020, the ROC had granted extension for all companies to hold the AGM by 31st December 2020. But this is 2021, COVID is gone. So this had happened. Since matter was in the High Court, they kept on postponing it. But nevertheless, Dish TV went and told, Yes Bank is not the owner of shares. They cannot vote at the AGM. Very simple. 30th December, 2021. High Court rejected this petition on December 23rd, 2021. They said nothing doing. The agreement seems to be clear and they should be the owners of the pledged shares. Now, to give a bit of history, the battle between Dish TV promoters and Yes Bank started way back on September 7th last year, when Yes Bank called for the removal. So the moment they, got the shares, right, 25 point whatever shares, immediately they called for an EGM. They called for an EGM to throw out all the directors under section 169. Again guys, I am linking all the Companies Act sections. Section 169 read with section 100. Requisitioning an EGM. Who is requisitioning here? Remember section 100. Who can requisition? Any shareholder with 1/10 of the share capital, that is 10% of the share capital, can requisition an EGM. So, Yes Bank, by invoking section 100, since they had 25 odd percentage, obviously minimum required is 10%, called an extraordinary general meeting for the removal of all the directors, including the promoter director Jawahar Goel, through an extraordinary general meeting. Now the thing is, they said when you are not even a shareholder, the share should never have come to you. How dare you raise a EGM request? So that matter went to High Court. Again fighting there in the High Court, right? The EGM till today has not been held only, imagine, right? This litigation now has gone up to the Supreme Court also based on the question of law. What is the law here? Should the shares be owned by Yes Bank was the question. So in one of the cases, there are so many cases going on. In one of the cases, the Supreme Court has told that whatever the case may be, I need to restore the voting rights to YBL because the contract seems to be very clear. Though you have raised a question of law, the contract seems to be clear and the voting right should go to what? Yes Bank Limited. That is a Supreme Court case regarding the ownership going on separately. And now I have also a High Court restraint order has come saying that until the matter will be decided by all the courts put together, you will not exercise your voting power. Where in the AGM. When is the AGM? December 30th, 2021. First of all, there is a violation of Companies Act there in AGM provisions, right? Moving on. Company had also informed that it has moved a suitable application in order to place the voting rights in a sealed cover before the Honorable Bombay High Court. Since Bombay High Court was hearing this particular case, they said, sir, AGM will happen, don't worry. But YBL's ownership, I don't know. But nevertheless, sir, I will put it in a sealed envelope and give it to you. What they'll give? Results of the AGM. Okay. Now, YBL filed its complaint dated December 31st, 2021. AGM had happened. AGM results they knew. But the company was not ready to file the results. Guys, every listed company as per SEBI regulation number 42, LODR regulations, have to mandatorily file the results of the AGM within 2 working days of the AGM. Right, AGM happened on December 31st, 2 working days, January 1st, January 2nd. So by January 2nd, you should have given the results to SEBI. It is a mandatory filing requirement for all listed companies. So we started with CA Inter, we started with CA Foundation, we started with CA Foundation concept of pledge. Now, we also saw CA Inter concept of section 96 AGM. And can you, postpone the AGM, adjourn the AGM. Third point, SEBI regulation, CA final, within 2 working days. We also saw CA final, 2 other sections, CA Inter and final both, section 100, requisitioning an EGM and removal of director. Are you understanding, guys? Next, now SEBI regulation, within 2 working days you have to do, they didn't do. So Yes Bank Limited lodged a complaint with SEBI. SEBI understood all these things and released the first warning, that is called the first advisory. When? That is 17 January 22. 17 January 20, not 23 obviously, 22. They said there was no direction whatsoever from the Honorable High Court not to publish the voting results. They said, boss, case was going on there, I agree, but they never told not to publish the results. Where have they told in the order? They have rejected the petition, but they never told you not to disclose the results. Why aren't you disclosing the results? Please disclose to everybody. It's a public company, listed company. What are you doing? The company is therefore advised to disclose the voting results or outcome of the AGM held on December 30th, clearly mentioning the directions of the High Court. Immediately you do it. When did they tell? January 17, 2022. Now, Dish TV replied to SEBI telling that, sir, sorry, sir, case is going in the court of law. I will not do it. It is sub judice. It is sub judice. I will not, sub judice means case is going on, I will not disclose. SEBI got annoyed. SEBI sent one more advisory, final warning. February 9, 2022, final advisory. SEBI once again reminded the company about its statutory obligation towards shareholders and other stakeholders and failure to act in compliance with the regulations. They sent a letter saying that please disclose the results which were declared on December 30th, 2021. Then they said the final warning, boss, if you don't do it, I shall take appropriate action against the company. Dish TV said, sub judice, case going on, I am not going to disclose. So guys, in one of the most landmark orders, right, SEBI, what did they see? They opened the High Court order to understand whether High Court has told in any line, just again to read, they said whether in any line they have told, do not disclose, do not disclose. If High Court has told, okay, I may agree. Now, when you read the High Court decision, there also it has clearly said, pendency of the above interim applications have no bearing on the requirement by SEBI. Clearly they have given there. SEBI is always in addition to Companies Act, in addition to other laws, but not in derogation of. So nowhere it says that you can't do it. Why aren't you doing it? Boss, SEBI declaration result, declare the results, no? Dish TV said, no sir, if I declare the results, problem will happen, share price will reduce. They are giving some nonsense reasons. Then, beautiful. It is one of the, generally I always used to tell in the class, they can give such directions as they deem fit. Dangerous it was. I had given you other examples, but this is the best example that I can think of to make you understand what do you mean by such directions as they deem fit. So by the powers vested under 11.1, 11.4, 11B1 of the SEBI Act, the order was passed. When was it passed, guys? I'll show you the order. The order was, passed. This is, I read the full order now. March 7, 2022, just a few days back, by S.K. Mohanty, who is a whole-time member of SEBI, right? So, obviously, this is just the gist of the story. I have read all the material there. I took almost 1 hour to read everything and made a gist of it. That is enough for you, right? So, what does it say? They said, first one, compliance officer, Mr. Ranjit Singh. He is the compliance officer, company secretary of Dish TV. Shall immediately now, March 7th, within 24 hours, you have to disclose the results. I am directing you, that's it. And board of directors should ensure that there is strict adherence to this provision. Second, depositories shall immediately upon the receipt of this order, guys, deadly, freeze the demat account of all the directors. Freeze the demat account of compliance. One share also they will not buy from any other company. Freeze it. And till the time the voting results are declared, freeze the damn thing. Freeze the demat accounts. It is one of the most deadliest orders ever passed. As practical example. Then they also told, they have given some 5-6 pages I was reading about how there should be a culture of compliance, how you should maintain high ethical standards, how individual directors are required to perform their duties, due diligence, care, dignity, honesty. Indirectly they are telling the directors of Dish TV, bro, what are you doing? You have to ensure that it's a public company. People should know the real deal, what is happening. What are you doing? So guys, then the results were declared. Crazy. Results were declared. I'll show you. See, if you see there, adoption of accounts. As regards adoption of accounts, check out. What is the percentage? 78%. 78% what? Against the resolution. 78% against the resolution. Regarding adoption of accounts, in that public non-institution 73%. Public institutions 98%. So basically 98, 73 all put together, overall votes, 78% of the votes. Result declaration gone. Next, reappointment of Ashok Mataya Kurian, director liable to retire by rotation. 79% said no, I'm not going to do it. 79%. These were the results. Then ratification and remuneration of cost auditors. 53% said I don't want that cost auditor. Let him get out. So 3 things were there. All 3 they lost, my dear friends. All 3 lost. What is the scene now? So they declared it a couple of days ago only. What is the scene now? The board of Dish TV has proposed the appointment of Rajgopal Chakravarti Venkateshaya as a nominee director on the board, days after shareholders voted against the reappointment of Ashok Kurian. So they now have come up with a nominee director concept, and they have appealed to Securities Appellate Tribunal against the interim order of SEBI. As of today, March 13th, when I am recording this video, these 2 things have happened. So you have understood Inter, you have understood Foundation, you have understood SEBI. There are 4 things that happen at the AGM. Adoption of accounts is very important. If it is unadopted, you will have to adopt the provisional accounts later. It will be adjourned. At the adjourned AGM, you have to adopt. But in this case, we'll have to see what will happen, guys. Very, very interesting case. One more case which I used to show in class, if you remember, is of course the Jet Airways case. This was in June 17, 2021. Jet Airways is also one of the cases where the shareholders refused to adopt the annual accounts. In this case, they have not given a reason as to why. They have simply told cases are going on. That's why here Jet Airways case, lot of IBC case, PMLA case against the promoter, and of course your lot of loan defaults were happening. That is why they failed to adopt the account. So if you see here, my dear friends, Jet Airways they did not play around. They immediately declared the results. See, 94%. I have shown this in class. 94% have voted against adoption. This was the first example of non-adoption of accounts. June 17, 2021. And whereas appointment of auditors as such, they have said, okay, appointment of auditors, okay, no problem, I approve. But the accounts itself, I am not going to adopt because there are a lot of frauds going on. I did not get a true and fair view of the books of accounts. So guys, this is the scene with respect to Jet Airways, and this is the most recent example of Dish TV. So we have learned through this the concept of pledge of shares, how it works, which we studied in CA Foundation, etc. And CA Inter concept of section 96 and section 100. 96 is AGM, 100 is EGM, who can requisition AGM. CA final of section 100 and 169, removal of directors. And of course, SEBI regulations we have seen, and SEBI sections 11, 11, 4 with specific thrust on such directions as it may deem fit. So for every aggrieved order, I can go to whom? I can go to SAT. So it's pending in SAT as of today. So this, my dear friends, this is how you need to read. This is how you need to study. Conceptual study everywhere, but you need to study it together, and this is how you need to decode the Bayer Act and decode the law. Okay, I want to share this with you. Hope you enjoy. Thank you so much. Cheers.